So the Pietermaritzburg High Court's ruling that all leases signed between the Ingonyama Trust and tenants for occupation of ancestral land are invalid has been hailed as a victory for rural communities. So in 2020, a group of mostly women under the banner of the Rural Women's Movement went to court complaining that they were tricked into signing leases for ancestral land on which they've been living for decades. The court has sided with these communities and has also ordered that the Ingonyama Trust pay back millions of rand collected in rent over the past couple of years. The Legal Resources Centre instituted the application in 2018 on behalf of the Council for the Advancement of the South African Constitution, CASAC, and the Rural Women's Movement. To discuss the significance of this court decision, let's speak to Lawson Naidoo. He's the Executive Secretary of CASAC, joining us via our video link. Lawson, always great to chat to you. Thanks for making time once again for 405. So what the ruling does in some respect is affirm that whilst the land in question is in fact under the custodian of the Ingonyama Trust, it still belongs to the people.
Indeed, and that was one of the most important parts of yesterday's judgment, is that the court has affirmed that the true and beneficial owners of the land are the people who reside on the land. The Ingonyama Trust is a mere custodian of that land. It is held in trust for the benefit of the residents of KwaZulu-Natal, and this judgment affirms that important principle and provides the basis for people living on that ancestral land in terms of Zulu customary law to have a proper title to that land.
So if that is to be our starting point, then we should appreciate that what actually happened here is that people were tricked into paying rent on land that they own. How did that happen?
Well, this was a decision that the Ingonyama Trust took several years ago and started a process of what they call the PTO conversion project, which is converting permissions to occupy, which are rights that are held by residents on the land in terms of Zulu customary law, and converting those informal rights, if you like, to formal leaseholder arrangements, which had a duration of 40 years, and which for the first time required those residents to pay rent to the Ingonyama Trust for the land that they occupied. This had never been done before, and the court ruling yesterday has set aside that PTO conversion project, saying that it is unconstitutional and invalid, and that any and all monies that have been paid by residents must be reimbursed by the Ingonyama Trust.
Yeah, so I guess one can imagine a situation where communities themselves would agree to have an arrangement where they pay money to the Ingonyama Trust for whatever reason. But the issue in this instance is that there was actually no consent given. Do you know how they got to a stage where they actually signed these leases, even though they don't necessarily agree with the arrangement?
Well, in many of the instances, and amongst the 7 individual applicants that were joined in this matter together with CASAC and the Rural Women's Movement, were testimonies of how people were duped and tricked into signing these leasehold arrangements. They didn't understand what they were signing. They certainly were not made aware that what they were signing would require them to pay rent for land that they had occupied for centuries in their families. And the court found that this was therefore invalid. The contracts were in English. Many of the residents were not conversant with legal documents in English, and were therefore tricked into signing these arrangements. And only later did they find that they had to pay money to remain on the land. They had to fence the land and do certain things that the trust demanded of them, which involved them incurring considerable expenditure that they must now be able to reclaim.
What is also significant about this ruling, Lawson, of course, is that government has also been ordered to put together measures, policy, legislation to ensure that this doesn't happen again. Only time will tell whether that will happen. But do you envision what those interventions might look like? What exactly needs to be done? Where are the gaps?
Well, another important finding from the court yesterday was that the Minister of Land Affairs, Minister Tokodiza, and her predecessors had failed to carry out their responsibilities in terms of Section 25 of the Constitution, which requires the state to put in place a process to formalize informal rights or customary law rights to land over a period of time. They have failed to do so, and the court has now ordered the minister to take steps to implement those provisions and to report back. Importantly, the minister is now required to report back to the court every 3 months on progress that is made in that regard. So the court is going to maintain oversight over that part of the process to ensure that the government does what is legally required of them.
Yeah. What I'm trying to get at, Lawson, is where was the law lacking, if that's where the problem was actually, which enabled us to get to where we are? And in answering that question then, what new legislation needs to be introduced to safeguard communities from people essentially signing documents that they don't understand?
Well, I don't think the law is at fault here. I think it's the practice that has been at fault, both by the Ingonyama Trust, acting in a manner inconsistent with the law and with the Constitution, and similarly with the government and the minister, not conforming to the responsibilities that they have in terms of the Constitution to formalize customary law rights to the land. So it's not the law that is at fault here. It's the conduct of the Ingonyama Trust and the conduct of government over the last 27 years.
Part of the justice, of course, must see to these people getting their money back. The court has ordered as much. How much are we talking about here? And perhaps as you answer that question, Lawson Naidoo, help us understand how this is not actually just about money. It's about the dignity of these communities as well.
Well, I think that's the most important part of it, is the dignity and people no longer feeling vulnerable, liable to eviction from land that families have occupied for generations. So that restoration of dignity and really meaningful citizenship as belonging to that piece of land and belonging to the Republic of South Africa in terms of the Constitution, and not the arbitrary conduct of authorities such as the Ingonyama Trust. So that's fundamentally important. We don't know exactly how many people have been affected by these leasehold arrangements. We've had many reports, and many people have come forward. But ultimately, it's going to be the responsibility of the Ingonyama Trust, who coerced people into signing these lease agreements, to produce those agreements and to account for how much they received from each of these households, and to make arrangements for the reimbursement of all monies that have been paid.
It's a High Court ruling. That suggests to me there may very well be an appeal. Have you heard from the Ingonyama Trust about where to from here?
No, we haven't heard anything as yet, but I would suggest that on the basis and the strength of this judgment, let us not forget it's a unanimous judgment of a full bench of the High Court in Pietermaritzburg. It's a strongly argued judgment, really pointing out to the deficits in the conduct of the trust and the minister. I would see very little room for an appeal in this regard.
It does feel like it's also a precedent-setting judgment. I wonder in what ways you think it will inform the ongoing debate around the amendment of, I think, Section 25 of the Constitution for land expropriation without compensation. Help us place this ruling in that discussion, if you can.
No, I think that that's an important part of this judgment, because it really highlights and pinpoints where government has failed in terms of its responsibilities under the Constitution. As I said, to formalize customary rights or informal rights to land. This is something that is clearly spelled out in Section 25 of the Constitution. Government has failed to deal with it. So we can't talk about a meaningful land reform program and restoring the dignity of people to the land if government fails to take its responsibility seriously. So this is going to have an impact on land under the control of traditional authorities across the country, because government's responsibility is not restricted to land under the custodianship of the Ingonyama Trust in KwaZulu-Natal, but extend to all such land under traditional control across the Republic of South Africa.
Indisputably a major victory, this one. Congratulations for the work you've done and for the contributions you've put in place to allow this to be the outcome from the court itself. Lawson Naidoo, thanks very much indeed. He's Executive Secretary of CASAC.